Good afternoon. Welcome to Legal Lunch with Laura. Today's webinar will be 30 minutes long. I selected this particular time slot with the intention that you would be sitting at your desk anyway, grabbing a bite to eat, and could use the time to your advantage to get some education about current events and interesting topics in the employment law world that are applicable in your workplace. If you have any questions during the seminar about the topics being discussed, please use the question box on the right-hand side of your screen. I will do my best to answer your questions during the webinar, or if time does not permit, I would be happy to answer your questions via email or have a follow-up discussion with you offline. This webinar is being recorded today, and the PowerPoint slides will be available on Afik Herman's website, which is www.afikherman.com. Look for Legal Lunch with Laura and the date, April 26, 2012. We have two very interesting topics to discuss today. The first is social networking passwords. Are employers permitted to ask for passwords to employees' personal accounts? Who owns the accounts if they're used for business purposes to benefit the company? Who has the right to access your Facebook, your LinkedIn, or your Twitter account? The second topic we'll talk about is the NLRB's workplace posting. We'll discuss the Federal Circuit Court's April 17, 2012 decision on the mandatory workplace poster. I invite you to join me for future webinars discussing interesting employment law topics on the third Tuesday of every month from noon to 1. Please mark your calendars for the following dates: May 15th, July 17th, September 18th, and November 20th. Also, if you have suggestions for topics you'd like to learn more about during your lunch hour, I encourage you to email them to me, and I'd be happy to include them in future webinars. First, some background about privacy related to social media websites. In 2010 and 2011, the State of Maryland Department of Public Safety and Correctional Services asked job applicants and current employees for their username and passwords to social media websites as part of the department's background investigation process. The process was discontinued after an employee with the agency claimed that the process violated his personal privacy. As my mom used to say, you think? Imagine your employer tapping into your private pictures, posts, links, thoughts, and friends. Hence, the Maryland legislature passed a new law called Maryland Electronic Account Privacy Protection. The law prohibits employers, including state and local governments, from requesting or requiring applicants or employees to disclose their username, password, or other means of accessing a personal email account or internet service. The bill also the bill also prohibits an employer from penalizing or threatening an applicant or employee for refusing to disclose the information. However, as most laws, there are exceptions. In this case, there are two exceptions. First, the employer may require disclosure of a username, password, or other means of accessing non-personal email accounts or internet services. Again, non-personal email accounts or internet services that provide access to the employer's internal computer or information services. For example, I have a criminal prosecutor friend who set up a fake profile on Facebook to obtain personal information on potential criminal witnesses in certain cases that she's handling. That profile would be deemed non-personal, and she would have to share login access information with her supervisors. The second exception is that an employee may not download an employer's proprietary or financial information to the employee's personal website or other internet site or account. In other words, a disgruntled employee cannot post a private list of customers or pricing or other confidential data. Note that because states don't have any jurisdiction over the federal government or its actions, this law does not preclude the federal government from making inquiries of its applicants and employees for their personal and private information. So, for example, you can rest assured that President Obama's newly assigned Secret Service agents will undergo rigorous scrutiny to ensure they do not have any history of hiring prostitutes in foreign countries. So I'm sure they're, my colleagues sitting here laughing with me. So you can be rest assured that the federal government, in doing their background checks, will be seeking and checking their personal social networking sites. Similarly, those in the military or private industry whose jobs require a top secret federal clearance, such as for a U.S. Customs broker's license, would not be subject to Maryland legal protection and could find themselves in the future having to disclose this kind of information. I want to ask you all a question, whether you all have a personal LinkedIn account that you use for business purposes. So in a moment, you will see a question pop up, and if you could just answer a simple yes or no. Let's see, where the results are coming in. Most of you are, interesting. The majority of you, about 56% of you answered yes, and about 44% of you answered no. That number keeps changing, I guess, as folks are answering, but it's almost pretty even, which is pretty interesting. Most of us, or at least I guess half of us, must use their LinkedIn account for professional purposes. Often it's to stay in touch with professional colleagues, join professional organizations, market, maybe look for another job, or stay connected with current professional events. And I'm looking again, that number it looks like it's pretty set. About 52% of you listening in do have personal LinkedIn accounts that you use for business, and 48% of you do not. Next, let's talk about the case everyone seems to be talking about that is pending in a federal court in Pennsylvania. The case is Eagle versus Morgan. In that case, on preliminary motions, meaning the full merits of the case have yet to be decided by the court addressed the question of ownership of a personal business networking account under the facts presented. Briefly, let me explain what the facts were. This case was brought by the plaintiff, Dr. Linda Eagle. Dr. Eagle had invested time, effort, and money in her career over a long period of time, developing her reputation in the financial education industry by speaking in conferences, publishing in journals, magazines, newspapers, and traveling the world to meet banking leaders. In 1987, Dr. Linda Eagle and another fellow founded a company called EdCom to provide financial education services and training to clients. In 2008, about 20 years after founding the company, Dr. Eagle set up a LinkedIn account in which she identified herself as the owner and founder of EdCom and provided information about her background. 2 years later, EdCom was purchased by a company, and although Dr. Eagle stayed on as an employee, she was later terminated. When she tried to log in to her LinkedIn account after being terminated, she was denied access. One of the new owners changed Dr. Eagle's password and routed those searching for Dr. Eagle on LinkedIn to a page featuring the name and photograph of a woman named Sandy Morgan, who was one of the new executives that took over EdCom. However, Ms. Morgan's LinkedIn account listed Dr. Eagle's honors, awards, recommendations, and connections. Dr. Eagle claimed that the defendants hijacked her account to prevent her connections from reaching her and to acquire business connections for the benefit of EdCom, and they misappropriated her account, costing her time, money, loss of goodwill, and damage to her reputation. In this lawsuit, both parties filed several claims and cross-claims against each other. The new owners of EdCom claimed that under Dr. Eagle's management, the company that she founded implemented a policy that she was a part of writing, requiring EdCom employees to do 4 things. First, utilize their company email address for LinkedIn accounts. 2, utilize a specific template created and approved by EdCom for their description of EdCom, work history, professional activities, as well as photographs taken by a professional photographer hired by EdCom. 3, links to EdCom's website and telephone numbers had to be on the employees' LinkedIn accounts. And 4, EdCom's template for replying to individuals through LinkedIn. Designated EdCom employees monitored these LinkedIn accounts, corrected violations of EdCom policy, and maintained the accounts for several employees for the benefit of EdCom, including Dr. Eagle. EdCom personnel developed and maintained the connections and content for Dr. Eagle's LinkedIn account. Dr. Eagle claimed that the company's takeover of her account invaded her privacy, misappropriated her identity, and used her name without authorization. This case obviously involves several complex issues, and the parties are currently embroiled in the discovery phase of litigation, where both sides are examining documents, taking depositions, interviewing witnesses, etc. A trial has not been scheduled, but there are obviously several novel issues that the court will have to address, including who actually owns a business networking account. It seems the case may hinge on the unique circumstances of the case I've discussed, such as the company's degree of involvement and control and their unfettered access to the employees' LinkedIn accounts. Most companies I advise have not to date attempted to monitor their employees' LinkedIn accounts or establish policies surrounding social and business networking. However, I suspect that after this decision is handed down and similar cases are decided across the country, employers will think more seriously about whether they want to implement policies. I can see employees, labor unions, and other employee-represented groups raising issues of invasion of privacy, etc. So I advise you all to stay tuned. This issue has not fully been vetted by the courts. Another case was decided in a federal court in Minnesota about 2 years ago in March 2010, addressing a company's attempt to protect its interests in social media platforms. That case was called TEKsystems versus Hammernick. In that case, the company, TEKsystems, sued its former employee for communicating with her former coworkers on behalf of her new employer by, quote, connecting with them on LinkedIn, allegedly in violation of her non-solicitation agreement. The problem with that case is that the former employee's non-solicitation agreement did not explicitly address a prohibition against social media or LinkedIn connections. The court did not address the merits of that case, unfortunately for us, and to help companies live by precedent, because the plaintiff consented to the injunction. And the problem that the employer learned the hard way, obviously after spending a lot of money in legal fees, was that it had not drafted its non-solicitation agreement broadly enough. I assume that TEKsystems has since revised that document to include a prohibition of social media solicitations. Things you need to determine in whether you want to implement a social networking policy in your workplace is think about whether you, as the owner of the company or a director of the company, a manager of the employee, does the company really want to own the employee's social or business networking accounts? If so, the company needs to take an active role in establishing its employees' accounts, assisting employees with content, postings, personal and professional exchanges with their connections, perhaps photographs that are posted, as well as monitoring the content of these types of accounts. This can obviously be a very time-consuming endeavor, but one that may be worth the investment if that's the direction that your company wants to go. You should also draft a social media policy, whether or not you choose to monitor your employees' accounts. And then you also should regularly review the policy and its applicability to how your employees are using their accounts. Let's switch gears and talk about the National Labor Relations Board's mandatory posting. Let's first answer the basics for those of you who aren't familiar with the rule handed down by the board last summer. And I'll talk about the who, what, when, where, why, and how of this posting. In August 2011, the board published a final rule requiring all employers subject to the National Labor Relations Act to post a notice in the workplace informing employees of their rights to organize a union, to engage in collective bargaining, and to strike, picket, or take other concerted action and other rights under the Act. Now, just so you know, the National Labor Relations Act does not cover all employers or all employees. For example, it does not cover individuals who are employed by federal, state, or local governments, employees employed as agricultural laborers, those employed in the domestic service of any family or person in a home, for example, a nanny, those employed by a parent or spouse, so you can't unionize against your parents, those working as independent contractors, those employed as a supervisor in a supervisory or managerial capacity by the company, or those employed by an employer subject to the Railway Labor Act, such as employees of railroads and airlines. The rule further required that employers, by April 30th, 2012, next week, post notices to employees in conspicuous places, informing them of their National Labor Relations NLRA rights, together with board contact information and information concerning basement enforcement procedures. Now, this poster might sound kind of familiar because most of you are required to post posters in your workplace, not by the NLRA, but by other federal and state laws. For example, it's a requirement that you post employees' rights about workers' compensation, about wage and hour claims, about OSHA regulations. So this typically, I guess by and large, you know, what I usually say is that most employees don't really pay attention to these posters. They're in a conspicuous place such as a company bulletin board or in the kitchen. You know, sometimes there are other notices that tend to get posted on top of them. And by and large, employees really aren't paying attention to them. So there were a lot of issues that came up, and I'm sure they will come up in the future once this issue is ultimately decided about whether the employer should in fact post a notice in opposition of this notice, or would really that be too much information and no one's going to be paying attention anyway. So the poster was ultimately created by the National Labor Relations Board and is available on their website. In fact, the NLRB has conveniently made the poster available in a total of 26 languages. The board obviously wants their message communicated. But the rule and the poster have met with many fierce challenges. As you can see, I've listed 3 cases right now. Employer groups, such as the Chamber of Commerce, the National Association of Manufacturers, etc., filed suit challenging the rule, and the board initially postponed implementation until April 30th, 2012. On Friday, March 2nd, in the case National Association of Manufacturers versus NLRB, the district court, and this is the U.S. District Court for the District of Columbia, so the district court struck down certain elements of the rule but held that the NLRB did have the authority to require private sector employers to post these notices. And this rule applies to those unionized and non-unionized workplaces. The employer, I'm sorry, not the employer, but the National Association of Manufacturers appealed that decision to the D.C. Court of Appeals. I'll tell you about that case in a moment. In the meantime, there was a case decided on April 13th, 2012 in Chamber of Commerce of the United States versus NLRB. A separate district court, and this is the U.S. District Court for the District of South Carolina, ruled that the board did not have the authority to issue the notice posting the rule. Following that decision, on April 17th, 2012, the District of Columbia Court of Appeals granted an injunction agreeing to delay implementation of the rule pending the appeals process. The court wrote, quote, "The uncertainty about enforcement counsels further in favor of temporarily preserving the status quo while this court resolves all of the issues on the merits, unquote. The court is scheduled to hear more arguments on this rule and the poster in September 2012, when the parties will present oral arguments in the D.C. Federal Court of Appeals. The same day of the injunction, so again on April 17, 2012, the board, the National Labor Relations Board, announced on its website that it would again delay implementation of the rule and stated as follows. In view of the D.C. Circuit's order, and in light of the strong interest in the uniform implementation and administration of agency rules, regional offices will not implement the rule pending the resolution of the issues before the court. Board Chairman Mark Gaston Pierce said that the board continues to believe that requiring employers to post this notice is well within the board's authority and that it provides a genuine service to employees who may not otherwise know their rights under the law. I have another poll for you. What do you think the court will do? Do you think the court will ultimately side with the National Labor Relations Board and mandate the poster, or side with the plaintiff employer groups and decide that the NLRB had no authority to implement such a rule and that the posting will not be required? Let's see, I have your responses coming in. They keep changing. Let's see, 80, 20, 75, 25. I'm going to say, still have a few more responses coming in. I think we're good. Okay. Okay. Final answer here. We have about 74% of you agree that the court will side with the NLRB and mandate the poster. Pretty interesting. If anyone has any comments to support that, I'd love to hear what you have to read. I actually think the opposite. I think that the court will not mandate the poster, but that's just my personal opinion. So I'm happy to hear what you think, so feel free to write your comments in, and I'll be happy to take a look at those and maybe even read some. The fact of the matter is that these cases are big wins for employers, the three cases I just talked about. However, employers are still not in the clear. Employers should also expect further guidance from the National Labor Relations Board, including a possible modification or limitation of the notice posting rule. I'll be happy to provide updates on this issue during future webinars. Log on to my Twitter accounts or check for e-alerts from me. However, if you have any questions in the interim, do not hesitate to email me directly. I would be happy to answer any of your questions. For now, however, employers need not comply with the notice postings rule, the April 30th deadline effective date. The NLRB has made clear that it has chosen to suspend the effective date of the new rule pending resolution of current and possibly more anticipated litigation. One thing is clear, employers are well advised to stay informed of such developments and to prepare their workplace for a potential increase in union activity or at least union questions. Whatever the outcome, the important thing to remember is that the best way to prevent unionization of your workforce is to have open communication, fair and well-communicated policies, and a management staff that treats subordinates with dignity and respect. I'm always surprised to learn that survey after survey, employees prefer respect and acknowledgement for the work they do over higher wages. Of course, money is important, but there are far greater incentives out there for workers, and many people just appreciate a pat on the back and a thank you. I wanted to remind you of future lunch date webinars. Again, Tuesday, May 15th, July 17th, September 18th, and November 20th. Note this is the third Tuesday of every other month, and future webinars will be 1 hour long from noon to 1. And I hope you can join me at your desk with your lunch and listen in on some informative and current topics in the employment law world. So if anyone has any questions, someone wrote thank you. You're welcome, Michael. Thank you for the webinar. Very interesting. You're welcome. My pleasure. Any other comments about either of these topics or have any questions about anything else? We do have a few more moments, and I know based on the time of day, you may have a few errands to run or other things to take care of. So feel free. You're welcome. I have another thank you message. So feel free to email me directly. As you'll see up on the slide is my personal, my work email account, which I know is not private. So feel free to ask me any questions. And thank you all so much for your time for listening to me today. And I look forward to chatting with you in the future. Take care. Bye-bye.